Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Kathy Gillespie,
with students
Dakari Chapman
and me, Tova Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America.
Hi, everyone. Welcome to Constitutional Chats. We are so glad that you're here, and we'll ask that you come on in and join us. We are very excited today to have as our special guest, Dr. Jeff Sikkenga from the Ashbrook Center of Ashland University. And we're going to be talking about the role of the judiciary, Brutus XV and Federalist 78 in our Anti-Federalist versus Federalist paper study. But first, I'm going to take a moment and introduce our great panelists, starting with our moderator, our founder and co-president, the actress Janine Turner. We are so glad to have Janine with us today. She is famous for her role as Maggie O'Connell in television's Northern Exposure. She's the founder and co-president of Constituting America, which launched in 2010. And Janine continues to act, and currently she is starring this Saturday, September 25th. You can see her in the Hallmark Channel's movie, Taking the Reins. If you tune into the Hallmark Channel this Saturday, September 25th at 9 p.m. Eastern, 8 p.m. Central, and be sure and watch Janine in the movie Taking the Reins on the Hallmark Channel. Janine also speaks all the time about the U.S. Constitution. She's given over 540 speeches to classrooms across the country. Now, I also am very glad to be able to introduce today our media.
Hi.
Oh,
hi. Hi, everybody. Welcome to the show. We're thrilled you're here. It's going to be another great show. Appreciate it.
I think I may be frozen.
We can hear you, though.
Oh, great. Then I'll keep going. Glad to introduce our media director, Aubrey Jackman, who's responsible for all this fabulous technology. Aubrey is this year's We the Future Best College STEM winner. She's born and raised in Utah and is the middle of 7 children. Aubrey is a student at Brigham Young University and aspires to be an athletic coach. And Aubrey, I'd like to ask if you would go ahead of our poll so we can tell who's in the audience today.
Perfect. Yeah, I just put it up. So if everyone wants to just let us know what category you fit in, that would be awesome.
Wonderful. So while y'all are answering the poll, Aubrey, do you want to tell us just a little bit about the poll and explain it a little bit more?
Yeah, so we love to just put up this poll so that we are more aware of who's in our audience so that we can kind of tailor the show to you. So that's just why we put it up at the beginning of every show, and it helps us know just better what our audience looks like.
Great. So do we have enough answers to give some results, or should I go on to Tova, do you think?
Yeah, I think we have enough.
Okay.
So the largest group that we have with us today, we have 34% of parents and grandparents with children. And then we have 28% fans. Then it looks like we have 13% friends, and then 3% teachers, 3% college students, and we have 9% middle and high school students. So that's awesome.
Well, welcome to everyone. Now, we're also very glad to have on our panel today, Tova Kaplan. Tova is a 17-year-old student from Chicago, Illinois. She's a 3-time winner of the We the Future contest and is also the National Youth Director of Constituting America. Tova runs our Youth Advisory Board, as Janine likes to say, like a CEO. She is just a wonderful leader for all of the youth involved in Constituting America's Youth Advisory Board. Tova is passionate about inspiring young people to know and use their constitutional rights. Tova, would you like to say hello?
Sure. Hi, everyone. I'm so glad to be here as always and hope you enjoy the show.
Great. Now, we normally have on Jewel and Jordan Gilbert, but they are out of town today. So we are Very happy to have Jacob Vanderwerken sitting in for them. Jacob works as strategic manager for Constituting America, specializing in advertising and social media. He graduated from Brigham Young University with a Bachelor of Arts in Communications in the nationally top-ranked advertising program. He's a former winner of Constituting America's We the Future contest. Jacob was raised in Utah, where he currently lives with his wife, Emily, who also works for Constituting America and is a former contest winner. Jacob, would you like to say hello?
Sure. Yeah, it's great to be on. I'm glad that Jewel and Jordan are out of town so that I'm able to step in for them today.
Well, great. We're so happy to have you. Now, before I introduce Dr. Sikkenga, I want to take a moment and recognize our sponsors for today, Mr. and Mrs. Jay McConville. Jay is a longtime member of the Constituting America Governing Board and is so supportive of Constituting America in so many ways. He's leading our strategic planning effort. He's written 90-day study essays for us and even hosted a constitutional chat. And Jay's wife, Sue, is a talented artist and has donated paintings of dogs to our auction from her company, Your Dogs Painted by Sue. So Jay also very generously sponsored our live Constitution Day virtual workshops earlier this year. And I want to give Jay a special shout out because he most recently held a Facebook fundraiser for his birthday for Constituting America, where he raised over $1,200 for Constituting America from his Facebook friends. We want to remind all our listeners that you can hold a Facebook fundraiser for Constituting America for your birthday. It's really easy. You just go to Facebook and hit create a fundraiser, and Constituting America is one of the choices. So thank you, Jay and Sue, for all you do for Constituting America. We so appreciate your sponsorship of today's program. It's now my great privilege to introduce Dr. Jeffrey Sikkenga, again of the Ashbrook Center at Ashland University. Dr. Sikkenga is the executive director of the Ashbrook Center and professor of political science at Ashland University. Jeff has been at Ashland and connected to the Ashbrook Center since 1997, serving as an adjunct fellow of the center, a faculty member in Ashbrook's Teaching American History program, co-director of the Ashbrook Scholar Program, and interim executive director. Jeff has been a senior fellow in the program on constitutionalism and democracy at the University of Virginia, a visiting scholar at Stanford University's Hoover Institution, and the William E. Simon Distinguished Visiting Professor at the School of Public Policy at Pepperdine University. He's the author of a number of reviews, articles, and book chapters on political thought, the U.S. Constitution, and politics and religion, and has published several books, including History of American Political Thought. Jeff, welcome to our program today, and we would love for you to open and just give us a few of your thoughts on our topic for today.
Thank you so much, Kathy. Thanks to Janine and all of you all for having me. I'm really just delighted to be with you. The topic today is the continuation of your series, of course, on the Federalist, Anti-Federalist debate on the Constitution. And it just seems to me so timely, the topic that we're talking about today, which is the Supreme Court and the federal judiciary. It's back in the news, as everybody knows. There is a discussion again about the possibility, for example, of court packing and increasing the number of members on the Supreme Court. And I think the two documents that we're looking at to go back to these original debates really shed some light on why we have this controversy today over the Supreme Court. The Supreme Court was controversial when it was first proposed. Brutus essay number 15 was written by Robert Yates of New York, who actually had gone to the convention in Philadelphia, gotten there and said, wait a minute, I don't think they should be rewriting the Articles of Confederation like they are. And he left in protest, went back to New York and organized opposition to ratifying the Constitution. And part of that was writing these essays, criticizing the Constitution. And in this essay, Brutus number 15, Yates says, the problem with this Supreme Court is that it will be too powerful. He says, I believe that judges should be independent. That's a good principle of a constitution. And he says, the British have it right. Their judges are independent because they're there for good behavior, their life terms, and also because their pay can't be reduced. So they can be independent and impartial deciders of the cases that come in front of them. And he says, I like that idea. We should follow that. But he goes on to say in this essay, but this Constitution does way more than that for the federal judiciary. It makes them not just independent, but supreme. And he says the reason they'll be supreme is that they can interpret the Constitution. They can say what the Constitution means, and their decisions cannot be reviewed or overturned by anybody else. And he says in that way, we haven't followed the British model. So they're not just going to be independent, they're going to be supreme. And if I could just read a quick quote from him, he says this: there is no power above the Supreme Court to control any of their decisions. There is no authority that can remove them, and they cannot be controlled by the laws of the legislature. In short, they are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself. They'll think that they're gods, really, that can tell America what the Constitution is, what it means, and everybody will have to follow them. That's the argument that he makes in New York. And the situation in New York is very tense at the time of the ratification of the Constitution. It's either way, it could go either way. And if New York goes against the Constitution will probably fail. So the stakes could not be higher for this in this moment. In response to that, Alexander Hamilton writes Federalist number 78, which is one of the most famous Federalist papers. And certainly Hamilton thought it was some of his very best work. Hamilton's a New Yorker too. So he's responding in the newspapers of New York to Robert Yates. And one of the things that he says in Federalist 78, and it's written directly in opposition to this newspaper article that had come out. So it's dueling journalism here, way back in the time of the founding. Hamilton says this: Yates has got it exactly wrong. The Supreme Court and the federal courts will not be the most powerful. He says they'll be the least dangerous branches. And why is that? He says, well, because they can't make laws. And he says they don't have the power of the purse. They can't tax. He says they can't enforce the law. They have no sword. All they can do is make a decision. And whether that decision gets respected and abided by is up to the executive, the president, who will have to decide whether to enforce the law. The Supreme Court doesn't have its own army. It doesn't have its own police force. It has to rely on the president. And if the president decides not to enforce the decision, the Supreme Court's decision just stands there, ineffective. So he says it's not the most powerful, it's the least dangerous. And then he goes on to say, because you might say, well, what about its power to interpret the Constitution? That's what Brutus said would be so troubling. It could tell America, it could tell the president, it could tell Congress what the Constitution means. Hamilton replies to that. He says, that's a misunderstanding of what we now call judicial review, the power of courts to review the constitutionality of a law and strike it down. Hamilton says that is not meant to tell the other branches that they must follow this interpretation of the Constitution. It's meant to protect the federal courts in deciding cases that come in front of them. And he says, really, in Federalist 78, the power of judicial review is a shield to protect the courts. It's not a sword to hold over Congress, the president, or the American people. And so he actually makes an argument that it's a very limited power, not meant to give the court supremacy over everybody else, but to protect its own independence from being trampled on by the other branches. So he says Brutus has got it exactly backwards, exactly wrong. The court will not be that powerful. And I think it's really interesting for us today to think about, when you think about the Supreme Court and the controversies over who's going to be nominated to the Supreme Court, why do we fight about it so much? Well, because the Supreme Court has become so powerful. But what's really interesting is the original defense of the Supreme Court went out of its way to say, don't worry, it won't be that powerful. And I think it's fair to ask, maybe Brutus in some respects had some insight here into what the Supreme Court would become that was not so clear to people like Alexander Hamilton at the time of the founding. And those insights can help us kind of think through, should the Supreme Court really be as powerful as it is? So we can look at these original documents and we can see controversy over the Supreme Court is nothing new. And the controversy over how powerful it should be really continues from the founding to today.
That was succinct and specific and fantastic. You really laid that out well. That was really good, Jeff. I'm going to call you Jeff because it's so hard to pronounce your last name, and I know
Oh, Jeff is fine.
Okay. All right. I have some questions. I thought that there was a big controversy between Jefferson and Jefferson's cousin, who ended up being John Marshall. John Marshall was his, I think, cousin who ended up being on the Supreme Court. And he took over as Chief Justice after John Jay left to be the governor, which they thought was more powerful than the Supreme Court. So that tells you something right there. But I thought that Jefferson was very upset with John Marshall, the second Supreme Court justice, if I'm correct on that. I thought he was very upset because John Marshall sort of instituted judicial review, and that it was never supposed to be judicial review. And I don't think in the Constitution it actually says that they're going to be judicial review. And they never actually say that. And I think and that was a surprise to Jefferson. It made him very mad. So maybe the Constitution and Hamilton were correct in that it was never supposed to interpret the Constitution, but John Marshall did that. What are your thoughts on that? First of all,
That's a really great question. Yeah, I mean, I think it's definitely right. First of all, you're right that Jefferson and Marshall did not get along. They didn't get along personally from back in their time in Virginia, and they didn't get along in their sort of philosophy of the Constitution and the Supreme Court. That's absolutely true. If you look at Federalist 78, which was written in 1788, so what's that, 15 years before Marbury versus Madison, which is the famous case that you're referring to from John Marshall, Alexander Hamilton says there that the Supreme Court and the federal courts will have the power to declare acts of the legislature void. So that's what we call judicial review, as you say. So it's really interesting to me that 15 years before Marbury versus Madison, you have a founding father saying, oh yeah, the courts will have judicial review. So I think the dispute was not over that fact. What the dispute was, Jefferson's view was, okay, the Supreme Court can say that a law is unconstitutional. The question is, do I have to follow their interpretation? If I'm president, for example. That's the question that really divided Jefferson from other people. Jefferson's view was, they can say that it's unconstitutional. But do I as president have to follow that? Jefferson's answer was, no, I don't. Because I can interpret the Constitution myself as president. And if I disagree, then I don't have to follow what they say. So Jefferson accepted they had that power, but he denied that their power was superior to his.
was supreme. He denied that it was supreme.
He accepted
Right.
judicial independence, but denied judicial supremacy.
Okay. Well, I want to build on this, but first, legislative void. I mean, legislative void. Define legislative void. It doesn't seem to me that necessarily legislative void means judicial review. Does that mean because the legislative branch cannot interpret the Constitution? What's a legislative void?
That's a good question. I think there's a lot of dispute over that, actually. What Hamilton means when he says it in Federalist 78 is when a federal court declares that a law is void because it's unconstitutional. What that means is it does not operate in the federal court where the case is happening. So, for example, if a person, there's a famous case, Texas versus Johnson, burning the American flag. Back from 20, 30 years ago. Is that protected by freedom of speech or not? That's a big contentious issue. But if you're prosecuted under a law that says it's illegal to burn the American flag, for a court to say that that law is void means that you can't be convicted in their courtroom under that law. So in other words, void means the law does not operate in the courtroom. It doesn't mean necessarily that the president and Congress have to accept that view when they carry out their own actions. So it's for the judges when they carry out their actions in their courtroom, not necessarily for the president or Congress when they carry out their actions in making laws or enforcing laws.
But what does that have to do with judicial review? That's why I'm sorry, I'm just maybe.
That is what judicial review meant to Alexander Hamilton. He said, he is not saying in Federalist 78 that the Supreme Court can tell the president what powers he has and the president has to accept it. He is not saying that, actually. He's saying a court can say, Congress might think that this is what the Constitution means, but it doesn't mean that in our court. We're not going to accept Congress's interpretation. We're going to abide by our own interpretation in our courtroom when we're deciding this case. So in other words, it's a shield to protect the courts. It's not a sword that the courts can use to make the other branches do what they say.
I think I'm getting it. So in other words, with the burning of the American flag, the Congress can't really make a decision on that. So it goes to the Supreme Court. So that's the void. The void just means the legislative branch is not applicable, that they would take care of it.
That's right. It doesn't mean, that's right, exactly. So it means that if you're prosecuted in a federal court under that law, the judge throws out your prosecution and says, you can't be prosecuted under this law because it's unconstitutional. You're free to go. It doesn't mean, though, that Congress can still believe that law is constitutional. They can still disagree with the court, and they can still actually enforce, the president could enforce that law on other people. But then when it went to a federal court, the conviction would be thrown out. So it's much more about the way courts operate under our Constitution. Mm-hmm. It's to protect the independence of the courts in doing their job. And
we did want that separation of branches, which, okay, I have a few more questions and I have to turn it over. Okay, it's interesting that they also believed that the president could just ignore a Supreme Court decision. That's not what is accepted today. Today, everyone thinks the Supreme Court's decision is supreme. And I think, and you said that, but it's my understanding that the legislature can overturn a Supreme Court decision. If it's bad, they can go back to the legislative branch and change the law and say, okay. So in a way, I think that we think the Supreme Court is supreme, but the legislative branch, if they don't like something, can go make a law that negates the decision. Like I think they were trying to do that with Obamacare, right? They're going to try to negate the decision the Supreme Court made. So it's really not that supreme if the legislative branch can actually overtake it, which is my first thought. My second thought is Andrew Jackson. I thought it was there was some Supreme Court decision that they made that Andrew Jackson said, I'm not doing it. I'm just not doing it. And I thought that was so controversial that he was one of the first to ever do that. So it's interesting to me that the president just doesn't have to do it. Is that really, that's what our founding fathers believed? Because today, if Trump or Bush or Clinton or Biden were to say, I'm just not going to abide by that Supreme Court decision, I think everybody would be up in arms. So those are my two different things. But the legislature can overturn the Supreme Court. So it's really not that supreme, but also that presidents, it's really a little murky there because.
Look, those are two great points. And they really point to something that's important for us to understand, which is this idea that the Supreme Court is the final authoritative interpreter of the Constitution, that they tell everybody what the Constitution means and everybody just obeys automatically. That's not in the text of the Constitution. That is not that was not universally accepted at the time of the founding. It's something, as you're suggesting, that happened over time in American history. So what presidents opposed that view? Thomas Jefferson opposed that view. Andrew Jackson opposed that view. Abraham Lincoln opposed that view. Teddy Roosevelt didn't love that view. Franklin Roosevelt actually disagreed with that view pretty strongly. And then you have other presidents since, like President Reagan or even President Obama. People might remember the State of the Union address when President Obama was talking about a Supreme Court decision and the Supreme Court sitting right in front of him, and he criticized them to their face about the decision they made. So
but he didn't negate it. He didn't
negate it. No, but I guarantee you, he instructed his Department of Justice lawyers to find every possible way to work around it or circumscribe it as narrowly as possible. So I would say the last president who openly said, I don't think the Supreme Court's decisions are final, was Abraham Lincoln. Since the 20th century, we haven't seen it, but FDR came very close when the Supreme Court was striking down his New Deal legislation in the 1930s. He was this close from giving a speech. We know this from uncovering records in the archives, where he was going to say, the Supreme Court has said this, but for the good of the country, I'm not going to abide by it. But the Supreme Court ended up ruling in his favor, so he didn't give the speech.
Oh, interesting.
Yeah.
So I guess it's not as supreme as we think. But what's happening here is a set of logic with the United States Constitution and with history of what's actually precedents really are. We're ignorant to that. So we all just think that Supreme Court is supreme when really it wasn't really that supreme at all. So Hamilton was really correct in that, in a lot of ways, that he didn't have to worry. Okay, last question. I'm going to toss it over and we'll make this a kind of a lightning round answer. This is really, really fascinating, I think. The last question is, can you describe very like in 1 minute, the difference between how England's is not supreme, but ours supposedly is supreme, which we've just kind of said actually it really isn't that supreme. But I would like to really understand that difference about England's Supreme Court and how it differs from ours.
So, and Brutus makes mention of this in his essay. If you lose a case in England, you can appeal your case to the English Parliament, to the House of Lords. And when they sit in as a court hearing those appeals, they're called the law lords. And so you can actually appeal to the legislature. So something that Brutus wanted, for example, was you ought to appeal from the Supreme Court to the Senate. And the Senate should be the final court in the country to decide matters of the meaning of the Constitution. So he said that's the way Britain does it. And to this day, they still do it. There's been some modifications, but they still have that kind of a system. They don't have a British Supreme Court in the way that we do.
Now that could be, in conclusion here of my questioning, that could not work in our favor though, because the Senate becomes so incredibly political. And I know the Supreme Court is now political, but they're not supposed to be. You know, and I think sometimes they actually do rule in a non-political way occasionally. So I think if it were to go to the Senate today, we'd be in big trouble because it would just be so divided and it wouldn't be impartial at all. So I guess even though the Supreme Court is so divided, it's become political too, but it's not supposed to be.
I think that's right. And the way that Brutus and the founders were thinking about the Senate, that it would be much less political, much more, it would be elected by the state legislatures, for example. Now we have direct election. So it would just be much less partisan, much more sort of wise people. Yeah, wise people thinking everything through.
17th Amendment, that 17th Amendment changed everything. Okay, that was really fun. Okay, thank you. I'm going to turn over to Tova now. And you'll get to hear the rest of the great questions from the rest of the panel now. Thank you, Jeff.
Great, thank you. So, you know, as Janine was mentioning, I guess in modern times, although the Supreme Court was obviously intended to be a neutral body, with each judge not really having a political leaning, but just, you know, having their own opinion on the matter. But now, you know, we speak of justices as conservative justices and liberal justices, and every time a president appoints a new justice, it's like a whole big deal about, you know, oh no, like there's a conservative justice being appointed, or oh no, there's a liberal. So how does the fact that, how did we get to that point where now judges have pretty clear leanings, and how does that kind of change the effects of the Supreme Court and the way it runs?
Oh, that's a really good question. You know, from the very early Republic, there were Federalist judges and Democratic Republican judges, and everybody knew it. One of John Marshall's great abilities as a Chief Justice was to get everybody to kind of agree with him, no matter where they came from. So Thomas Jefferson would keep, and the Democratic Republicans would keep appointing justices who they thought would interpret the Constitution their way. They would go and hang out with John Marshall, and pretty soon they'd be voting like John Marshall. And this was one of their great frustrations. So this idea was known, you know, way back in the early Republic. But I think what has happened is, because the Supreme Court has gotten so powerful, and in everybody's mind, its job is to tell us what the Constitution means, and it's the final word on that, that the way they approach it and think about it is really now investigated very deeply. And people start to think, they don't say, what's this judge's judicial philosophy? They say, how is this judge going to vote on these issues? Because the decisions matter so much more, and the Supreme Court takes on so many more cases on all kinds of issues that are hot button issues. So I think it's the court, precisely the court expanding its decisions and being so powerful that has people so concerned about the judge's political views as opposed to their judicial views.
Well, thank you. And then, we were talking earlier about how the Supreme Court has become so powerful. There are not many ways around a Supreme Court decision. But what if there was, what if we got to a point where there was a truly corrupt justice, or we got to a point where the court wasn't making decisions based on the Constitution? Like, for example, like with the Dred Scott decision, that wasn't really based on the Constitution, but was more just based on racism. Or for decisions like that, is there any way around it, or you just have to wait until the Supreme Court changes their mind a generation later?
Yeah, that's a great question. There are ways around it. There are ways, and those ways are still sort of used these days. I mean, we can't forget that a Supreme Court decision still has to be enforced. So the Supreme Court can make its decision, but Janine referenced John Marshall. Andrew Jackson said, John Marshall has made his decision. Now let him enforce it. If there was a really corrupt decision, the president of the United States could simply say, they've made their decision. I respect that they have the right to do that, but I, in good conscience, cannot enforce this decision. Or I will enforce it in the narrowest way possible, because I believe this decision is fundamentally corrupt, unconstitutional, and wrong. They could do that. And there have been moments in American history where the decisions of presidents to enforce the decision of the court were really important, like Brown versus Board of Education, desegregating public education. Dwight Eisenhower, Little Central High School in Little Rock, Arkansas, right? And the black students who were being admitted, and they were being told they couldn't come. Dwight Eisenhower, as president of the United States, had to decide, am I going to send United States military troops to Arkansas to enforce this decision or not? And if he had not done that, that decision of Brown versus Board of Education wouldn't have meant very much in Little Rock, Arkansas at that time, but he decided to do that. So there are ways that the Supreme Court, even though it has a lot of authority, still is limited in its power and has to rely on the other branches.
And the flip side of that question, vice versa, if there was a really corrupt president that just said, I don't want to enforce a Supreme Court decision no matter what, is there anything the Supreme Court could do to get around that? Or are they dependent on fully dependent on the cooperation of the other branches?
Yeah, I mean, they can issue an order forcing the president to do it. Marbury versus Madison was about the Supreme Court issuing an order to James Madison to do something. James Madison had no intention of doing it, by the way, if they had issued that order. They didn't do it. But if the Supreme Court could issue an order, they did it to President Nixon to produce tapes on the Watergate scandal. He ended up turning them over. He protested it. If he had said no, they could have issued another order. But then what do you do if this president ignores their order? Then it would be up to Congress to take up impeachment proceedings, for example.
Wow. Okay. Thank you. And then what do you think, this is a contentious topic, but what do you think of the idea of court packing, which has been coming up recently? Is it regardless of your opinion, is it constitutional? Is it something that a president could do? And then further, do you agree with it, or do you think the founders would have agreed with it?
Yeah, that's another really good question. Yeah, first of all, the Constitution doesn't say how many people will be on the Supreme Court. In fact, it doesn't give any qualifications for the Supreme Court, unlike the president, unlike the Senate or the House. There's no age limit or anything else, or minimum. So yes, Congress could by law change the number of justices from 9 to whatever it decided. And it has changed the number of justices in the past. I think we've had 9 since about 1869, but they could change it, and it's been contemplated before. So constitutionally, legally, it is definitely within the power of Congress to pass that law and the president to sign it. There's no question about that. Now, is it a good idea? Is it a wise idea? Even just recently, Justice Stephen Breyer has come out with a book saying that should not be done. He said, even though he might agree with some of the critics of the Supreme Court on its particular rulings, he thinks for the sake of preserving judicial independence and for the sake of preserving the idea that the court is not just another political institution, but it's really supposed to be the kind of impartial judges that Janine was talking about. For that sake, there shouldn't be court packing, even if it might work temporarily for one side's favor politically. It's a bad idea. It will undermine the authority of the court. Because Justice Breyer says in his book, look, all we have in the end, we're just 9 people with robes. All we have in the end is our moral authority. And if court packing undermines that, we lose the authority and power that we actually have with the American people.
Wow, that's powerful. Thank you. And then also, why do you think the founding fathers decided to leave the judicial branch so open to interpretation? It seems like for people so incredibly worried about, overreaches of executive power and, the Federalists and the Anti-Federalists, why would they just, leave that open for executive interpretation?
Well, I think 2 reasons. I think they, first of all, as Hamilton says in Federalist 78, they didn't think that the Supreme Court or the federal courts would be very powerful because they didn't have the sword and they don't have the purse. And if you don't have money or guns, you don't have real power in their mind. You might have authority, but you don't have real power to make things happen. So I thought on the one hand, they said very clearly, it's going to be the weakest of the 3 branches. The real action is going to be in Congress. The real action is going to be in the presidency, not really in the Supreme Court. That's one thing. And the truth is the Supreme Court didn't even have its own building until 1935, unlike the Capitol building or the White House. So I think that just kind of goes with this idea, it'll be fairly weak. And I think the other thing they assumed is, look, everybody knows judges will have to be lawyers. They'll have to be people at least who are learned in the law, who have a kind of legal background and familiarity with the Constitution and the legal issues for them to get appointed. Hamilton says that at the end of Federalist 78. He says these will be learned people who have been students of the law who will be appointed as judges. So I think that you combine those 2, it'll be weak, and probably we all know that's the kind of people who will be appointed, just led them to not lay out criteria. But I do think you're right. It's kind of interesting and a little puzzling that they didn't say a little bit more about the kind of people they thought should be on the court.
All right, Tova, all finished? You good? Okay. Yeah, I just think it's really interesting that the legislative branch can overturn the Supreme Court and the president technically can too, and no one seems to know that. It's kind of fascinating. All right, Jacob.
All right. Tova asked a lot of really great questions, and a lot of those questions were also the ones that I had. So I'm glad that Tova asked them, and thanks for describing them well. I know, like Tova said, court packing is really a controversial topic right now. And with that in mind, what's your personal opinion as far as do you think it's better to have less or more people in the Supreme Court? Do you agree with that justice who wrote that book and described that? Yeah, I think that this is preserving our political, maybe not our political affiliation, but more our moral bias and where we stand morally as individuals. Do you agree with that and that statement?
I think so. I mean, I think 9 is enough. I think that, the Supreme Court has control of its docket now, which means it decides what cases it gets to hear and what cases it doesn't hear. That wasn't always true. It wasn't true until 1925, actually. So they had to hear all these appeals, and there were so many appeals that they just had more work than that they could possibly do. Now that they get to decide their cases, they only decide with full opinions about 70 cases a year or so. I think with that kind of workload, I think 9 is enough. There's the Ohio Supreme Court, for example, one state Supreme Court has 7 members. And I was just talking with the Chief Justice of the Ohio Supreme Court, who was here at my university talking to our Ashbrook scholars about what she does on Constitution Day. She was here and she said, I can't imagine a court of 9. That seems like too many. But she has 7. So I think 9 is enough.
That's really interesting. Okay. And then there's a lot of talk, obviously about a lot of different things, but one thing that I find really interesting personally is that the president is the one who appoints them, right? And the president has a lot of power with the Supreme Court. And this could be dangerous per se to people who feel strongly to one political party or another, because as we've seen, this is where court packing starts coming up. Because if hypothetically people from one political affiliation, even though they're supposed to not be affiliated with parties, but maybe they have bias towards that, if they all die, in theory, we could really stack a court very high with those that fall in line with one president's view. Do you think that process is fair with seeing like the political divisiveness of today? Do you think that that's okay, that process that we have, that in theory we could have a 9-0 court?
Yeah, I mean, that has happened before. When Franklin Roosevelt was president, it was a 5-4 split against him. The Supreme Court struck down a bunch of New Deal legislation. That was in 1937. By the time you get to 1942, all the members of the court were pro FDR. So all those decisions that had been 5-4 against him were now 9-0 in favor of him. So that has happened in the course of history. If a president is there long enough or has enough appointments, not just on the Supreme Court, but on the lower federal courts as well, where there are hundreds of judges that get appointed. So yes, a president can really swing things, but sometimes we live a little bit too much in the present. Vacancies will come up, sometimes very unexpectedly. And then the pendulum sort of swings back. And you see this if you look at the last 40, 50 years on the Supreme Court. And it also turns out, as Janine mentioned, justices don't always vote how presidents think they're going to vote. In fact, very often they don't vote how presidents think they're going to vote. Just to take one part of the Constitution, the Fourth Amendment, no unreasonable searches and seizures. If you looked at it and said, how will the quote liberal justices vote? How will the quote conservative justices vote? You could never figure out who was who if you looked at that part of the Constitution and how they vote. So it has much more to do with their judicial philosophy rather than with their political affiliation or which president appointed them. And sometimes presidents are very bitterly disappointed with the justices that they appoint.
Yeah, that's really fascinating that they could be very devastated. If there were to if there were to become an issue where maybe the court became so packed that it didn't change for a long time, do you think that would constitute like an opportunity for it to be under review? Or do you just think that, as you're kind of saying, the pendulum just eventually will swing? Do you think there's ever a time for like a Supreme Court justice to be asked to resign or step down in order to make it more fair, or is that unconstitutional in itself?
Well, there have been times when justices have been asked to step down. So William O. Douglas, who was appointed by Franklin Roosevelt in 1939, was still on the court in the early 1970s. And people thought it was time for him to resign and step down. He had been there long enough, and some people thought he was getting a little erratic on the court. And so they asked him to resign, and he refused. And so finally, they got his wife to essentially get him to resign, and he did. But however, he showed up the next year at the Supreme Court with his robes on, saying, well, I'm an emeritus justice, I'm going to sit on these cases. And everybody had to tell him there's no such thing as that. So sometimes putting pressure on justices to resign works. Sometimes it doesn't work. Sometimes it backfires. Many people wanted Ruth Bader Ginsburg to resign so that President Obama could appoint a successor, and she refused. So it really is up to the justices. And I think we sometimes forget that they really do view themselves as fiercely independent. They really think, Ruth Bader Ginsburg thought, I might have been appointed by a Democratic president, but that doesn't mean I'm therefore going to resign so a Democrat can appoint my successor. Because I'm Ruth Bader Ginsburg, I'm a Supreme Court justice, and I'm here, as the Constitution says, during good behavior. So they become very fiercely independent of themselves as justices and of the Supreme Court as an institution as well. And sometimes, therefore, they'll make surprising decisions, like I said, that really run contrary to what the president who appointed them thought they were going to do.
Fascinating.
So if it persisted for a very long time and the pendulum never swung back, then you might see some people saying, maybe we need a constitutional amendment for age limits. Maybe we need something else. But I think it would have to go very far that way. And I don't think we're close to that yet.
Okay. I have one final question, if that's okay, Janine, unless you want to take over. Court. Okay. My final question is with that, if with like the swinging and everything, because that's really fascinating. You describe it really well. And you've obviously studied this much more than I've been able to. But as far as everything that you've learned and with court packing and all of this hot topic, what is your personal take? Do you think that the Supreme Court as it stands is good enough or is operational in a way that benefits the people? Or do you think that there are changes, whether large or small, if any, do you think that there are any changes that should take place today that would help the Supreme Court operate in a more fair way?
I like the fundamental structure of the Supreme Court as the founders gave it to us. I think if there was any constitutional change that I would be open to, I think might be an age limitation. So that, but I don't know what that age limitation would be. Obviously, when the Constitution was written, people didn't live as long.
Right.
And so, you know, your body gave out before your mind gave out. But as we know today, that's not necessarily true. So I think there have been some proposals to put a maximum age on the Supreme Court. But on the other hand, there have been some older justices who have been very good jurists and really wise in the way they've approached the job. So it's something I think I'd have to be very careful about. And I personally don't think the Supreme Court in that respect is broken. And my view is if the Constitution's not broke, we shouldn't fix it.
Yeah. Okay. Yeah. Thank you. That's really fascinating. Appreciate all your insight.
Thanks, Jacob. Good questions as always. Like you and Tova, great and good questions. Great and great questions. Good and good questions. Okay, Kathy, you are on. And I just want to reiterate before I toss it to Kathy one more thing. The president constitutionally does not have to execute, so to speak, a Supreme Court decision.
If the president believes that the Supreme Court decision is fundamentally corrupt or unconstitutional, the Constitution does not explicitly require the president to carry out that Supreme Court decision.
Yeah, that's just really good to know today. Didn't we all learn something? Didn't we? These are so great. All right, Kathy, go ahead.
We did. And just to make sure I understand what you're saying, Jeff, in that same vein, you're saying that the Congress can make laws and the president can sign them and execute them. The Supreme Court might say those laws are unconstitutional, but the only way that law would not be would be struck down, I guess, is actually in court. But that doesn't stop the Congress from passing a law or the president from signing it.
Yeah, and we have examples of that. We have an example of in 1990, the Supreme Court made a ruling about religious liberty in Oregon versus Smith is the name of the case. In 1993, 3 years later, Congress passed the Religious Freedom Restoration Act. And they passed it, by the way, almost unanimously, which almost never happens in Congress, as we know. And they explicitly said in that law, this is in response to and correction of the Supreme Court's decision in Oregon versus Smith.
Yeah, well, I think we definitely have all learned something today. We've also got some great audience questions. Robert Casimiro asks, how is it that a judge, say, in a court in California, can make a ruling that affects the whole country?
Yeah, that's a great question. So a federal district judge can issue an injunction, can make a ruling that has to be abided by in the whole country, or can issue an injunction, which is a judicial order to stop doing something. And there have been, and I would say this has proliferated in recent years. The old view was that if a federal judge makes a ruling, that ruling is only good in that judge's district. Or if it's a circuit court, because there's district courts and circuit courts, it's only good and binding in that geographic region of the country where the circuit is. So you could have different interpretations of the Constitution in different parts of the country. That's happened many times on all kinds of different issues. And then those bubble up to the Supreme Court, which then makes a decision that is effective for all the federal courts across the country. In the meantime, though, different courts make different rulings, and the Constitution means different things in those areas. That's not uncommon at all. Lately, we've had federal courts that will say, a federal court in California, as the questioner suggests, that makes a ruling that doesn't affect just what's happening in California, but affects it all across the whole rest of the country. And we've had some Supreme Court justices say, I think we need to take a look at that as a Supreme Court. That might be an abuse of the judicial power. That might be carrying the power too far. Maybe it's not supposed to operate across the whole country if you're just a federal judge in San Francisco, California, for example, but it's supposed to operate in San Francisco, California, and leave the rest of the country to decide according to the federal judges who are in the rest of the country. I think that's going to be an important issue that the court takes up in the next 3 to 5 years.
Very interesting. And then Robert Summers has emailed in a question asking, what are the different ways that a case, or I guess a case is what you would call it, can come to the Supreme Court? Obviously, I mean, it can bubble up from the federal courts, but are there other areas that the Supreme Court has jurisdiction in, such as a state versus a state?
Yeah, those are some interesting cases. So they can get, the court has appellate jurisdiction, which means it hears cases based on appeals from lower courts, lower federal courts, or the state courts. When there's an issue of the federal constitution or US law involved, the state, you can appeal from your state court. And by the way, most cases that get to the Supreme Court come from the state courts, because the state courts do 95% of the judicial business of this country. And that's something we kind of forget. We don't realize how important state courts are, state Supreme Courts are. They're extraordinarily significant in our constitutional system, and they're meant to be. So they do most of the hard work of judging in this country. Most of the appeals go from the Supreme Court, from the state courts to the Supreme Court. That's its appellate jurisdiction. It also has, under the Constitution, what's called original jurisdiction, which means it's the first court to hear the case, state versus state. Those are unusual. They're rare. There's only a dozen or a couple dozen a year like that. The Supreme Court, that's basically, they're sitting as a trial court then. They don't usually do that. What they'll do is they assign the case to what they call a special master, who's usually a retired federal judge of some kind or some kind of magistrate who has some particular expertise in the issue. And then they'll ask the special master to write up an opinion deciding the case. And then they'll take that and they'll give that kind of their stamp of approval, that decision. They kind of farm out the work to these other folks because obviously they're busy with their appeals jurisdiction. A lot of these cases are, a lot of them are state versus state out west. They're fighting over water rights. That's pretty typical. There's a very famous original jurisdiction case. New Jersey was opposing New York over who owned Freedom Island, where the Statue of Liberty and all that is. And each was claiming they owned it. And so they sued, went to the Supreme Court immediately, and the Supreme Court had to make a decision, and they farmed the decision out to a special master. And the master decided that New York owned the parts of the island that were rock, and that New Jersey owned the parts of the island that were landfill.
Oh, wow.
So that's the kind of original jurisdiction cases. In that case, it didn't matter very much, but who has rights to certain water in the West really does matter.
Definitely, definitely. Now, Teresa Speak has a question again about the size of the Supreme Court. And Teresa mentions that there's a current proposed constitutional amendment called Keep 9. And what do you think of a constitutional amendment to set the number of Supreme Court justices at 9?
As I said before, I like the number 9. I think 9 is enough. I'm reluctant, me personally, so I understand the impulse behind it. I'm reluctant to amend the Constitution. That's just I think as a general principle, we should be reluctant to amend the Constitution. And if the founders didn't specify a number, we should be very careful about putting that number in ourselves. I prefer to leave it to the political process to play itself out. Court packing is, even FDR at the height of his popularity in 1936 and 7, could not get court packing passed because there's this constitutional principle in the American people that says you should not undermine the independence of the courts. And if you're packing the courts because you want a certain outcome, then you're undermining the independence of the courts. I prefer to leave it to the political process and political argument rather than having the Constitution set it, because there might come a day when the number shouldn't be 9. And then we're going to have to amend the Constitution to change that. And I think that's a legal issue not really a constitutional issue. But I certainly understand the impulse. And like I said, I personally support 9.
Okay. And then Noel Tokarov says, all 3 branches of our government are narrowly limited in their responsibilities by specifically enumerated powers. The founders never intended for the Supreme Court to act as the final decision maker on all social issues that we face. Its function is to make sure that the other 2 branches do not assume powers in violation of the Constitution. Since the Supreme Law does not mention regulatory agencies, is most of what happens in the executive branch illegitimate?
Well, that's a big question. And I can tell you, this is coming onto the Supreme Court's radar. How much power should, under our Constitution, should regulatory agencies have independent of the executive branch? For a long time since the New Deal, that's been basically accepted. Lately, some lower federal courts have been saying, I don't think we should accept that so easily, because a lot of those agencies have legislative power, they can make rules. They have judicial power, they can interpret the rules that they make, and they have executive power, they can enforce those rules. That seems like a violation of separation of powers, a basic principle of the Constitution. And people have said, I think courts should not defer to that. Courts should be much more aggressive in saying, do you really have that power that you think you have, executive agency? And frankly, there's a role for Congress in this. Congress has gotten in the habit, in my opinion, of delegating way too much rulemaking authority to the executive branch. Congress should be making the laws that govern the American people, not leaving it up to executive agencies to figure it out. That's, I think, absolutely required under our Constitution, and it's just good practice. You know, one of the things that me studying the Supreme Court, I've come to the conclusion is that the interpretation of the Constitution is not the Supreme Court's job, it's everybody's job. It's the president's job, it's the Congress's job, and it's the American people's job. And I think we have sometimes given that up too much to the Supreme Court. I'm in favor of anything that gets the people and their representatives much more deeply involved in understanding and interpreting our Constitution.
Well, and I think that's a great way to wrap up our program for today. And that's definitely what we at Constituting America are trying to do is help people understand our US Constitution more with great expert guests like you. And I'll toss it back over to Janine.
Yeah, I think these programs, these chats have just, I don't know, I've learned so much. I think they're just truly fascinating. The closing remark I'll make is that would be a great amendment to the Constitution. Are the czars, the bureaucracy, the bureaucrats that have so much power, whether the legislative branch is farming it out, because they farm a bunch of things out too. They create all these agencies. Environmental Protection Agency was created by the legislative branch, right? Wasn't it, or was it the executive branch?
The legislature.
Yeah. So, I mean, they create all these agencies, and then this what you're just saying, right? And they have all this power, legislative, executive, they make their own decisions and they're not elected. That would be a good amendment to the Constitution, I think. Would it not? You don't even think?
And you know what, Janine? We don't even need a constitutional amendment on that if Congress just took back the power that it should already be.
Yeah, but they're not going. But they're not going to. And
well, that could be true.
Just like they don't ratify treaties because there's so many of them, and they just sort of get put in a drawer, and they're called executive agreements. They're just going to say they're so busy and they don't have time. I just don't see it changing. I agree in principle, but I don't think it's going to change. And I agree with you that I don't think the Constitution should be amended very often, but I think we have forgotten what a great tool amending the Constitution is, because it can't just be overturned by the next legislative branch. Laws can come into effect and be overturned in 4 years, 4 years, every 2 years they could be overturned if they get a new house. And amendments, except for prohibition, really have never been overturned. So I think there's a lot of power in that. And that's a great amendment idea. I would love to see that as an amendment, quite frankly, in my personal opinion.
Well, hey, we'll call it the Turner Amendment.
There you go. I'll just write a petition about that. And then I'll use my speech, and then I'll call the press, and then I'll have an assembly. That's what I'm always teaching the kids. Well, anybody else have a closing remark? Jeff, I thought you were fantastic. Sikkenga, did I say it right? Sikkenga?
Yes, you got it.
Sikkenga. Did I say it right?
You did. Yes. Thank you.
Okay, goody. All right, thank you. You are terrific, simply fantastic, really clear, very concise, very clear, wonderful. Thank you so much. And I thank you for watching us today. And Kathy's going to tell you about the one we have next week. And Jacob and Aubrey and Kathy, if you want to sign off too.
Yeah, thanks so much. And thanks, Dr. Sikkenga. Definitely learned a lot. Thanks for having you.
Yeah, we definitely want to invite everybody to join us next Tuesday at 2:00 for our last in this series, our Anti-Federalist series, with the fabulous Professor Gordon Lloyd, who's going to be helping us wrap up and conclude this great series on the Anti-Federalist paper. And Aubrey, if you want to put up on the screen real quick our information about North Texas Giving Day. If you are in the North Texas area, Thursday, September 23rd is North Texas Giving Day, and we invite you, all of you North Texans, to go to northtexasgivingday.org and make a contribution to Constituting America. We actually have a matching grant up to $5,000 for North Texas Giving Day, so we invite you to contribute on that. And if you're not a North Texan, you can contribute anyway. Just go to northtexasgivingday.org, Constituting America.
Oh, really? You can join it if you're not from Texas?
You can, sure.
Oh, well, there you go. And just matching grant, for those of you who don't know, we don't get the 5K unless we get the 5K through Texas Giving Day. Yeah, then we'll get 10. That'd be great. And it sponsors programs like this.
Definitely.
All right. Well, I guess we did it. Aubrey, you want to sign off and say goodbye too?
Yeah, we're just so glad that everyone was here with us today. And if you want to share this podcast with any of your friends, it will be on constitutingamerica.org shortly. So.
And then it goes, don't we put them up on other venues too?
Yes, they're on YouTube, Spotify, iTunes, SoundCloud, wherever you like to get your podcasts.
There you go. We're just so hip. Thanks to Jacob and Emily and Aubrey. Aubrey does it, and Jacob and Emily get it out there, and Kathy too. Not I. You will not catch me doing anything mechanical or technical. That's all I can do to get on a Zoom. Okay. Thank you, everybody. Thank you. Appreciate it. Bye.
Thank you.
Thank you.